Great. Hello, everyone. This is Janice from the MBLS LITC. Thanks so much for joining us today. We're very lucky today to have Steve Kauffman speaking, and he'll introduce himself in just a moment. But first, I wanted to just kind of remind everyone that we do encourage everyone to join our pro bono volunteer panel. And if you're interested in applying the information that you're going to learn today, taking a pro bono case is a great way to do that. So, Stephen, if you'll please move to the next slide.
Oh, sure.
Great. So we have our pro bono portal, which is online, and you can see that there are different categories of cases. This portal is available 24 hours a day. So if in the middle of the night you have a burning desire to take on a pro bono case, this is a great way to find out what's out there and what's available. So next slide, please. So also, I do want to encourage everyone to follow us on social media, and we have a lot of upcoming training and clinics coming up. So please join us by following us on social media. Thanks. Next slide, please, Stephen. Great. So before we start, I'm going to just ask everyone that if you do have questions, please feel free to put them into the question box. We're going to try to hold most of these questions until the end of the session to discuss them so we don't interrupt the flow of the presentation. And I just also wanted to know that Stephen has been very generous in allowing us to post the slides as well as the webinar on our website afterwards so that you can continue to use it as a resource. But from now, I'm going to let Stephen take it over. Steve,
Thanks,
go ahead, please. Thanks.
Greetings, fellow tax mavens. Let's go to the next slide. We were supposed to do this initially, I think, back in April, and there were some issues that arose, so I haven't really looked at it too carefully since then. So the first slide deals with it's triggers giving rise to an IRS contact. So you know, what's going to give rise to an IRS contact, and kind of ranking them in terms of, you know, the highest risk, the most likely to lead to a contact versus lower risk. And I guess the highest risk would be filing a return with a balance due on it. As we all know, when that happens, we're going to receive a series of service center notices that are going to become increasingly more emphatic about collecting that money for Uncle Sam. Now, I guess the next act or omission in this case would be failing to file a return. And if you don't file a return, and if there are information reports that have been filed with the service, W-2s, 1099s, K-1s, those sorts of things, they may trigger what's known as a substitute for return under Section 6020B. The IRS has the authority under that code section to take available information and create a return for you. That's called a substitute for return. So that's fairly high risk as well. And then finally, if you file a return that's inaccurate, if income is mischaracterized or omitted, if deductions are overstated, that could give rise to a contact by the IRS. That's a little difficult to quantify that sort of risk in the abstract, but you know, it really that could lead to an audit. There are different kinds of audits. There are office audits. You can get basically correspondence audits where there's mathematical errors, that sort of thing. Office audit is going to be focused on just maybe a couple of items on the return conducted by office examiners. And then, of course, you've got, you know, depending on the results and appeal, etc. That's a whole nother presentation. All right. So these are the triggers. Certainly not not exclusive, not all inclusive, but these are primarily the triggers that will give rise to an IRS contact. So why don't we move to the next slide, which is the notice sequence. And the tax delinquency, that means that there is a balance due. A lot of times the IRS refers to these things as TDA, tax delinquent accounts, starts the sequence. And one of the things you may see from time to time is a notice of assessment and demand for payment. And the service is required to do that. It's I believe it's under 6303, but don't hold me to that. Then you'll get a balance due notice. And then you'll get a final notice before levy. And we'll talk a little bit more about that, and that's going to trigger your right to file a collection due process request. Or there can be a notice of federal tax lien that's actually filed, and the filing of the lien is what triggers the right to file a CDP. In other words, your CDP rights with respect to a lien arise after the lien has been filed. Now, one thing that's kind of interesting as far as liens are concerned is when the general tax lien arises, and that's, I believe it's section 6321. I hope I have that right, 6321 of the code. And the tax lien arises when there's an assessment. An assessment means the IRS is just writing the liability down on your account and its records, all right? And that can be an assessment based on a filed return or an audit or anything. So you have an assessment, you have a notice and demand that we just talked about. So they send you, the IRS sends the initial notice and the demand for payment, and a failure to pay within 10 days. When those three occurrences converge, then the tax lien, the general tax lien, automatically arises. Okay, and that's called the secret tax lien. And keep in mind that's totally different from the notice of federal tax lien. The notice is another step beyond that. But as between you and the IRS, between the taxpayer and the IRS, not you guys, because you guys all pay your taxes and file timely, and so it's a wonderful life. But as between a delinquent taxpayer and the IRS, that's when the lien arises under 6321. Okay, and sometimes that can be important in different contexts, tax and non-tax contexts. So let's move on to oh, I'm sorry, I went backwards. Let's go forwards. Responses. Let's talk about the responses, how we respond to notices. And I guess the default is to do nothing. And that's most of my clients are in that category. By the time they get to me, they've done nothing, and all kinds of bad things have happened. And when you do nothing, you can wind up with enforced collection action. So, what is enforced collection action? As we just discussed, one tool that the IRS has is to file a notice of federal tax lien. And when the IRS files the notice of federal tax lien, that puts the world on notice. It's a public record. There are tax practitioners out there who, get databases when these notices are filed, and they send letters to delinquent taxpayers. They're published in different periodicals. It can cause embarrassment. It can trigger default under commercial loan agreements or other agreements, it can be, a notice of lien can be very, very problematic. Another collection tool that the IRS has is they can issue a levy, or they can seize property. And a levy, for example, a levy of a bank account is going to seize whatever is in the account at that time. And it seizes it for a period of time. I can't remember the exact time, 21, 23 days, something like that. But the funds are seized, and then if nothing happens during that interim period, the funds will be taken by the IRS. Now, a bank levy is different from a wage levy, because a wage levy is continuous, and that can create serious problems for a taxpayer. And if there's a wage levy in place, even when you file a CDP, that doesn't automatically mean that the IRS is required to release the wage levy. Typically they do, but it's not automatic. So try to avoid certainly any levy, but particularly a wage levy. Now, the other thing that's interesting about the levies is, let's say that taxpayer owes $100,000. And let's say when a levy is served on the bank, there's $10,000 in the bank account. And then the next day, $90,000 comes into the bank account. Well, what's actually frozen is the $10,000. And despite the fact that the other 90 comes in would be sufficient to pay off the liability, it's the levy is only effective to seize what's there when it's served. And then at the end of that time, the government would take $10,000, and if they wanted to have access to that account again, they'd have to issue additional levies. Assets, of course, can be seized, and you don't see that as much, but it does happen. They can, for example, levy receivables. If there are government receivables, that can be automatic. And then the service can also, in certain situations, notify the State Department not to renew or issue a passport to a delinquent taxpayer. So that's if the taxpayer, the delinquent taxpayer, does nothing. These are some of the enforced collection actions, the most common enforced collection actions that the IRS can take. Now, the responses could be to request a cap appeal on Form 9423. That's an approach. It's very quick, and there's no appeal rights beyond the cap appeal. Another thing you can do in certain circumstances is request a taxpayer assistance order on Form 911, and sometimes that can be effective. And then finally, you can file a CDP request on Form 12153, and that's one of the things, that's what we're going to be discussing today. Now, filing the CDP request has some consequences. One of the things it does is it stays enforced collection action, subject to some exceptions, but it will stop any enforced collection action. It also tolls limitations on collection. Now, what do I mean by limitations on collection? As everyone knows, there's this legal concept of the statute of limitations. And statute of limitations, a lot of people who aren't trained in the law think they understand what that means, and lots of times they do. They have a very general knowledge of it, but the limitations is a lot more complicated than people realize. And in the tax arena, of course, we have limitations on assessment, and that's called the so-called ASED, A-S-E-D, Assessment Statute Expiration Date. And the general rule is that the assessment statute expiration date is 3 years. Now, as always, there are exceptions to that rule. If you have a substantial understatement of income, omission of income, or overstatement of deductions, and by substantial we mean 25%, then your limitation period on assessment is 6 years. If a return is not filed, or if a fraudulent return is filed, then there's no limitation on assessment. Okay, so those are the general rules for assessment. Collection is a little different. The limitation period on collection, and that's referred to, you'll hear it referred to frequently as the CSED, Collection Statute Expiration Date, is 10 years. But there are occurrences that toll that limitations period. And by toll, we mean it stops the running of the limitations period. And one of those things is filing a CDP request. So there may be situations where a CSED is imminent. Maybe there's a situation where the CSED is 6 months for a big period. And maybe there's not a lot of funds that can be levied, et cetera. And what your client may want to consider in a circumstance like that, whether it's better just to, deal with that levy such as it is and let the CSED expire, or file the collection due process request. That's certainly something that should be considered along with many other things. Now, another effect of filing a CDP request is you get a review by an independent appeals officer. All right, and they're gonna give it a fresh look because you've been trying to deal with a revenue officer and you couldn't come to terms with the revenue officer. Of course, in the collection arena, you're trying to determine the RCP, the reasonable collection potential. And the term that's used for that by the service is RCP. And to determine the RCP, of course, there are going to be collection information statements, 433A for non-business, 433B for business. They're going to look at the net equity in assets. They're going to look at monthly income less allowable expenses, and then use those numbers to calculate RCP for different purposes, whether it's offer purposes or if your CDP request is timely. All right, so there's a regular CDP request and what we'll call an equivalent hearing, where if you're untimely, but if you file within 1 year, you get an equivalent hearing. So there's no right in the context of an equivalent hearing for any judicial. Or that you're filing in response to that final notice. One of the things you can look for if the notice is indicates that the service can take your client's state tax refund. That's generally the penultimate or the next to the last notice that will trigger the right to file CDP request. So let's go on to the next slide. Now, there are exceptions to the CDP right. So if there's a determination made that the collection is in jeopardy, that somebody's going to take a great deal of money and leave the jurisdiction or whatever, then that's going to be an exception. And of course, you have those same exceptions in the assessment context. You have jeopardy assessments, termination assessments, etc. As I mentioned, state tax refund, the IRS can levy a state tax refund, and you're not entitled to a CDP request to prevent that. A federal contractor levy is another exception. If your client is a federal contractor, there's a program in place, automatic, and the government, IRS, and Treasury can actually receive or intercept and collect payments that would go to your client. It can be an extremely disruptive situation. And then there's also a disqualified employment tax levy exception. And the way that works is if you filed a CDP request for employment tax. What do I mean by employment tax? Tax on the 941 or a Form 940. For periods within the past 2 years. So let's say that there's a levy that comes out involving a 2019 period, and you filed a CDP request for a 2018 period, then for an employment tax, then the service can still go ahead and levy, but they still have to give you notice within 10 days after levying, and you can still file a CDP request for the subsequent levy. So those are some of the exceptions to CDP rights. Now, your CDP, and I'm not sure if it's on any of these slides, and if it's not, I apologize, but make a note of it now. The form that you want to use for filing a CDP request, and this is important, is the form 12153, 12153. And the issues that you can raise in a CDP hearing are, first off, procedural defect. And what do I mean by procedural defect? If you remember earlier, we talked about that after a tax is assessed, you need notice of assessment and demand for payment. That's a requirement. And if that's not done, then the lien doesn't arise. Many years ago, when I first started doing this stuff, had a case. It's the Blackston case, Blackston, where I argued that the service hadn't sent out a notice in demand. It's kind of an interesting case. We tried it, and Judge Garbus, who's a very, very knowledgeable, he's retired now, very, very knowledgeable judge on tax procedure. He kind of lectured me at the start of the case about a strong presumption of administrative regularity. But after we tried it, Judge Garbus held that we had rebutted that presumption because of some of the evidence associated with the case. But nonetheless, even though the lien didn't arise, the government was still, because they were within the time period, entitled to get a judgment. So it was kind of a Pyrrhic victory, but it was a victory nonetheless. And the Blackston case is still good law. It's cited from time to time, and it's out there. So, you know, if you ever have the issue, you might want to take a look at it, but you can certainly challenge a procedural defect. Another thing you might be able to challenge is the underlying liability, but that's only if you didn't have the ability to challenge it beforehand. So if we're talking about an income tax case that is going through, let's say, going through an audit. So you do an audit, you come to the end of the audit and it's unagreed, and then the government sends you a 30-day letter that gives you the right to file a protest with the appeals division. If you still don't agree, the government sends you a statutory notice of deficiency, also known as a 90-day letter. So if you get a 90-day letter and you don't file a petition with the tax court within 90 days, then you've waived your ability to challenge the tax prepayment. You still have the ability to challenge it by paying the full amount of the tax, penalty, and interest, and filing a claim for refund and doing refund litigation. But you've waived your ability to challenge it pre-payment and pre-assessment. Now, if you've waived it, then you can't, in a CDP case, challenge the underlying liability. But there can be cases, for example, where the statutory notice wasn't sent to your last known address, then maybe you can challenge the underlying. Other cases, the appeals officer is supposed to consider whether the enforced collection is no more intrusive than is required, balance the needs and legitimate concerns of a taxpayer. And then finally, you can propose collection alternatives. Collection alternatives might include an installment agreement, an offering compromise, doubt as to liability, doubt as to collectability, or what's known as effective tax administration. I'm sure there have been or will be webinars on both of those. And then seeing the tax is currently not collectible. So let's go on to the next slide. Now, the process, the duration of these CDP hearings really varies from case to case, and it has a lot to do with the facts and the complexity of the case and how complex your client's finances are. But the process, it's certainly not unusual for it to be many months after you file your CDP request before you have the hearing. And the hearing is informal, and it's generally conducted by telephone. And there are follow-ups, and sometimes they request additional information, and sometimes they'll send the case back to collection for a determination. You know, when you provide updated financial data to determine reasonable collection potential. And 6 months, 9 months, it's possible even longer. I've seen them last longer than that. Now, I reference the so-called record rule here because this is something that's important to consider if there's a lot of money involved, and if it appears that your client may want to take the CDP to the next level, to the tax court, if they're unsuccessful getting it resolved with the appeals officer. And the record rule is kind of interesting because under the Administrative Procedure Act, when you have some sort of litigation process, a judicial type process, there are some where you're entitled to present evidence in the form of witness testimony, documents supplementing the record. That's called a de novo consideration. And there are others where the court, considering what the agency has done, is going to be limited to the record. And in the CDP cases, when they go up to the tax court and you see the record, you'll be amazed. I mean, cases that don't seem all that involved can have hundreds of pages of documents, etc. And the appeals officer, revenue officers, etc., there are going to be these records of conversations that they have with you. And if you're bound by the record rule, what you'll find is that the appeals officer, the revenue officer, may have completely mischaracterized something that you said. But that's kind of what you're left for. So I think the important lesson here is to make sure that certainly all important conversations you document. And you know, if there is email communication, and sometimes there is and sometimes there isn't, send emails. I always encourage folks to really think through, you know, don't just do knee-jerk emails. Think through what you're writing and maybe wait till the next day before you send it, particularly if it's something you feel strongly about. Okay, but make sure it's complete, but also make it concise. Also, what you want to avoid is excess and duplicative production of documents, because that really makes the record huge, and it makes it cumbersome to if you are going to litigate something in the tax court to deal with that because the record gets unwieldy. And then finally, in your communications with the IRS, whether it's with an appeals officer or a revenue officer, the way I put it is write for the court. Just assume that everything you're writing is going to be read by a judge. So not a lot of extraneous stuff, not a lot of emotion, not a lot of negativity. Keep it positive, keep it factual, and keep it concise because there's only so many hours in a day. So that's kind of the CDP process. Now, after everything is resolved, the appeals officer makes a determination, and they send out a notice of determination. And in their determination, first, they indicate whether all the procedural requirements have been met, and they typically are. If they haven't, then that would be a problem because it wouldn't be proper for the service to exercise its enforced collection rights, levy or notice of federal tax lien, for example. The appeals officer then considers all the various issues raised by the taxpayer, including collection alternatives, and then indicates whether the proposed collection action, and this is the exact language, balances the need for the efficient collection of taxes with a legitimate concern that any collection action be no more intrusive than necessary. And in my experience, I don't know how much effort really goes into this balancing equation. The taxpayer advocate publishes annually what it considers to be some of the more serious problems in the tax arena, and once or maybe more than once they've spoken about this concern that maybe there really isn't much of a balancing that's taking place in this CDP context. But after the appeals officer makes their determination, then they will send out a notice of determination. All right, and the notice of determination is going to trigger your appeal rights. So when you get the notice of determination, if you disagree, then you have 30 days to file a petition with the United States Tax Court. There's a form, and you may not, you certainly should use the form as kind of a template, but maybe not the be-all and end-all, but it kind of shows you what needs to go into the petition. We discussed the de novo versus on the record, and I have a case that's pending in the tax court now. It's the Lowry case where the court asked us to address this issue, and the tax court takes a very expansive view of its role in this context, and it has pretty consistently held that in CDP hearings, even if it's CDP hearings where the underlying tax liability isn't being contested, it has the authority to do a de novo hearing where witnesses testify, it considers documents, etc. The IRS disagrees and is raising this issue in every circuit, and so far it's raised it in 3 or 4 circuits, and it has won in every one of those Circuit. So our case, depending on how it comes down, and I don't know how extensively the court would need to consider evidence beyond the record, although there were a few things that were not entirely correct. But our case would be either Fourth Circuit or the DC Circuit. So we filed our briefs in April or May of 2018, and we haven't gotten an opinion yet. So we're waiting for that. And then finally, if you're dissatisfied with the tax court, you have the ability to go to the Court of Appeals, the relevant Court of Appeals, and for most of the time in Maryland or Virginia, that's going to be the Fourth Circuit. Not all the time, but most of the time from the tax court. And beyond that, so that would pretty much, once you've exhausted your judicial review, then that would pretty much resolve. That would be, I guess, the grave, if you will, of the CDP action. Although appeals does retain jurisdiction to enforce its determination and for a reconsideration if there are any changed circumstances. So, see how we're doing here in terms of time. I guess we're okay. Let me see what the next slide is. Oh, questions and answers. So, I think we're just about at 45 minutes, which was about where I wanted to be. So I don't know if we've gotten any questions or answers, but if you think of something, here's my email address, and I've given you my telephone numbers, and I've also given you our catchphrases: results, not excuses, and a passion for the process. Isn't that great? Passion for the process, results, not excuses. Results, not excuses was a saying of one of my favorite old high school coaches. And I was out with some friends, and I said, I'm going to have to write him a letter because I always liked that. And my friend said, you're too late. He's dead. So I guess the learning point is, if you have somebody that you want to thank for something, or you want to say I love you, say it now. All right? But that's all I have. Thanks very much.
Well, thank you, Steve. So anybody who has questions, please go ahead and write them in the box now, and I'm happy to read them off and we can answer them. Thank you, Steve, for that very comprehensive review, starting from the birth, from the cradle of the CDP.
Well, we didn't get into the inception, but...
To the what? I'm sorry?
The conception, not the inception. We're good.
So, so I think it was very detailed, very step-by-step process through the life cycle of a CDP process. I remember when I first heard this title, I was a little confused by it because I was thinking of it in terms of human life, but Steve corrected me and said this was the life cycle of a CDP hearing. And I think these are all very valid points. Steve he did not really say much at the beginning, but he has been a tax attorney for many, many, many years and has had lots of experience in this arena. So if anyone has any questions for him, this is a good time to ask them. Or Steve is always very generous in his time and being willing to serve as mentors for our volunteers as well. So we're very lucky to have someone with such a wealth of experience who can respond to questions and discuss his own experience, his own personal experience in these issues as well. And of note, Steve just also re-engaged his CPA license. So he's got a different dimension there as well that can add to his knowledge base. So again, if anyone has any questions, please feel free to put them in. But it seems like this was a very detailed very comprehensive process here. And as I said, we will be posting his slides as well as the presentation on our website. So, so I think we're good here. I don't see any questions right now. I think it was explained so much that perhaps there aren't any questions. So. So, again, thank you all for joining us today. This is Steve's contact information on this last slide here. We, again, welcome you to take some of our pro bono cases and apply this information that you've learned today. It's a great way to really cement the process in your head, is to actually do it. And we do certainly have cases where this is something that's going to be happening. And we see this typically later in the process. As you were saying, Steve, you sort of don't, you start with, the IRS starts with letters, which get progressively a little more aggressive, and then at some point they send that notice of deficiency, which then leads you to this CDP hearing. Is that right?
Yeah,
Okay.
Janice, one thing that I might should mention here, when the taxpayer advocate was talking about the whole CDP process, okay, you can imagine how many millions and millions of notices go out, okay, including notices to give rise to CDP rights. But fewer than 1% of people exercise their CDP rights. And of the ones that exercise their CDP rights, fewer than 1%, and probably a lot less, exercise their right to appeal to the tax court. And of course, it's not justified in every case. But even at that, the volume of CDP cases in the tax court is incredible. So, it just shows you there's a lot of other, opportunities out there. And what I like about the CDP is the fact that it really gives you the time to work things out with the IRS, as opposed to taxpayer assistance, request for taxpayer assistance order or cap appeal. But that's really all I have to say on it. And thanks for having me. I've enjoyed it.
Great. All right. Well, thank you, everyone, for listening. And we welcome you next month for the next Tax Tuesday. Details to follow. Thanks. Take care.
Take care. Bye now.
Bye-bye.